Thank you so much for joining us. On a Friday morning at 9 a.m. We are here today with a PPA webinar to celebrate. So I called it a few moments ago like a PPA party. Not sure we have a party at 9 in the morning, but who's stopping us? Really to celebrate 25 years of having the LLP in the UK. Those of you amongst us who are eagle-eyed will say, Sarah, you're wrong. It's not actually 25 years because of the delay between the Act coming in to law and then obviously into force. But it's approximately 25 years, and we couldn't wait basically for another few months to a year to do an actual party celebration. Having said that, and I'm going to steal one of Rob's facts that he's just given me, the LLP actually first came into the world in 1991 in Texas. So we were a bit behind on that one in the UK, but never mind. So before I crack on with the content, I'm going to just introduce our speakers briefly. So we've got Rob Millard, who is from Cambridge Strategy, who obviously is a very well-known LLP and law firm strategist and consultant and advisor. And we're very pleased to have Rob with us this morning to share all his insights. We have got Mr. LLP, Jeremy Callman, who will be sharing a lot of the knowledge and expertise he has picked up over the time that LLPs have been around with us. And then last but definitely not least, we've got Corinne Staves, my partner at CM Murray, who is also an expert in LLPs. Obviously, like shameless plug, but Corinne and Jeremy obviously wrote a book on LLPs, so they actually did write the book. So I'm very honoured to be in their presence this morning. And Corinne's got a copy. I mean, you're one day late, Corinne. World Book Day was yesterday. If you dressed up as yourself, then, good on you. Yeah, you did. Did you send your kids to school as you? That's a step further, isn't it? So anyway, moving on. What are we going to talk about today? So we're going to have a look at various aspects of LLP. So we're going to look at how they work in practice, how they're used, but we're also going to look at some of the more technical aspects of LLPs and how we've seen that transition and develop, and what we think might happen in the future. Obviously, we are not Mystic Meg, but we will do our best to do a bit of crystal ball gazing as we go. So kicking off, Jeremy, we're going to start just with, I was going to say LLPs are obviously used across the board. And I think what we're all very used to is using LLPs in professional services, but we should also remember that they're used in other contexts as well, increasingly in financial services and sort of medical organisations as well. But one of the key things we've seen over the years since the introduction of LLPs is obviously a change in the makeup of what they look like. And what I mean by that is they've grown hugely in number, not just in the number of them being adopted and used, but in the numbers of LLP members that we see within firms. And I wanted to come to you first to get your experience of sort of how you think that has changed the LLP as an entity and the environment for those partners existing in those LLPs as those entities have grown larger and larger. And some would say look a little bit more like a corporate than they did when they started out 25 years ago.
Yeah, absolutely. Thank you, Sarah, and good morning, everybody. I think you started to put your finger on some of the trends that I think we've all been seeing, which is that LLPs have become more and more like corporates. So I think, and it's whether that's a function of the entity itself, of the mindset, or of the size of the organizations is perhaps debatable. But in any event, I think you're seeing more and more the idea that you can't really run these entities like you would run a traditional partnership historically, of everybody sitting around the table and making group decisions. And as they get bigger, you see more and more of the decision-making functions being hived off to a management board, management committee, or some other sort of more corporate style structure. And at the same time, obviously, you've got differences from a corporate because you've got, in principle, the members are all owners of the business. So there obviously are differences, but it does feel ever more corporate, I think. But as I say, whether that is a function of size or whether that is a function of the nature of the entity, I think is up for grabs. But certainly, I think when firms converted from traditional partnerships to LLPs, that was also taken as an opportunity to sort of have a look at governance, have a look at structures, have a look at how they wanted things to be run. Obviously, the fact that the LLP fundamentally has the added element of corporate protection, so that you're hopefully protecting the members from personal liability, unless you are silly about how you behave or how you've structured it, makes a difference. But I think more and more we see them being run like businesses, corporate businesses with different types of governance structure. And I think that has also an impact on mobility. I think that perhaps we see people maybe being a little less loyal in an LLP structure than they might have been if you switch the clock back to traditional partnership times, where it felt more like you were intimately involved in everything that was going on and in the decision-making processes. So maybe there are pluses and minuses.
And do you see a difference as between sectors? So I think as between, say, financial services LLPs and professional services LLPs, in that sort of attitude to trust, to like that sort of mutual trust that partners would go into partnership with, and how maybe that's eroded a little bit in an LLP. Do you think there's a difference? Or do you think both across the board LLPs you see that?
I think there is a difference. I think in the financial services context and in other types of sort of more inverted commas commercial contexts, I think very often, frankly, the members of LLPs are almost blissfully unaware that they're in an LLP and think they're just in a corporate and behave like they were in a corporate. I think it's fair to say that in professional services firms, say particularly law firms, there's still a sort of feeling that we're all in this together and that we're sort of partners in a corporate wrapper. So I do think the context does make a difference towards attitudes, and also how they're run makes a difference towards attitudes. I think the tone that's set in these businesses is very different. I very well remember, you may all recall, a very interesting APP session many years ago, not long in fact after the birth of LLPs, where one of the senior partners of one of the sort of very traditional law firms came on, and also one of the managing partner of one of the world's biggest accountancy firms, and they were talking about that both of them were quote unquote partnerships, and one of them, they said, well, we still meet for partners lunches and we still sit around the table and chat things through. And then the managing partner of the big accountancy firm said, when I communicate with my partners, we switch on a particular channel on the TV around the world, and I speak to my partners and tell them what's happening across the world. Now, those are two very different sort of creatures, both inverted commas partnerships, but just very different in their makeup and what's going on in terms of attitudes and relationships.
I'm going to jump quickly to Corinne and then to you, Rob, because Jeremy's touched on a point about use in other jurisdictions, and obviously what we've seen, I think, is despite being invented in Texas, which I'm slightly shocked by this morning, not knowing that fact. We do see that the English LLP being used across the world. Do you still think that's the case? Have you seen a decrease and increase? What do you think the future will hold?
So not Mystic Meg, Cryptic Cos you're after this morning, Sarah. I love it. Yes. Well, Cryptic Cos thinks that, yes, English LLPs will continue to be used. We do see them used in international structures at the moment. And the features that they have, it's not exclusive to English LLPs, around flexibility on governance and on profit sharing, are things that remain attractive. If you want a corporate company style business, you can have one. If you want a much more sort of partnershipy one, where your owners are actively engaged and involved in decision making, you can have that too. And I think that flexibility is appealing. I think that liability protection is key. I don't think I would say the same if we still only had general partnerships to lean on in that context. So I think that is incredibly relevant to the LLP. But honestly, Sarah, when we're thinking about international structure, the two things that really drive international structuring decisions are tax, which is obviously UK tax if we're thinking about the English LLP, but far more relevant, sort of the local tax regime, and regulation. And again, we're talking here about local regulation, the jurisdiction we're talking about, to sort of get this patchwork of entities, for example, LLPs or companies or however you structure your business, to make it work within the constraints of that. Well, the regulatory regime represents constraints. You either can or can't do things under the regulatory regime. Tax, it's about desirable outcomes, isn't it? And it's about sort of delivering acceptable outcomes to the partners.
Thank you. And Rob, what about strategy? When you think about whether going big has sort of improved the options for strategy, or people being more ambitious, less ambitious? What have you found in that respect over the years?
Well, of course, it's had a huge impact on strategy, and to understand that, one really needs to go back to the beginning. I mean, you mentioned the Texas invention, if you like, of LLPs back in 1991. That big shifts like this don't just happen on their own, or because somebody thinks it's a good idea. It's always in response to a shock that catches the attention of the legislators. And in this case, excuse me, I must apologize if I look a bit bedraggled. I spent last night on a plane, and I'm parked halfway between Heathrow and Cambridge at the moment, unshowered and unsafe, I'm ashamed to say. But back to 1991. So it was in response to the savings and loans crisis in the United States, which had the US government then taking action against over 1,000 firms, accounting and law firms. And then realizing that by taking action against these firms, they were probably going to drive them insolvent, which would mean that they would also drive all the partners personally insolvent. And that was determined not to be a good idea, not in the public interest, not in the interests of justice. And that is really what gave rise to to LLPs. It's useful just to understand the history, because it's so important to understand the impact on strategy. And then, of course, some years later, Jersey, implemented something that we would call today an LLP, and then the big six accounting firms, as they were back then, lobbied the British government for the accounting profession. And it was all around this liability and risk and joint and several liability specifically. So when you think about strategy, you have to think about how would strategy be different when you've got joint and several liability versus where not, where individual partners can make decisions without having to worry about whether some other partner is going to make their house be sold on auction, literally, because that's what it was like before. It didn't stop firms from being big. If we look at the Cowart Chance and Clifford Turner merger, which was back in 1987, that led to a firm that was over 500 lawyers. And in fact, the next merger, which was with Punda and the Rogers and Wells in New York, that was also before the advent of LLPs in the UK. But it certainly did make things a lot easier to grow, to take riskier decisions. It made it easier to borrow money, the removal of the joint and several liability, and the ability of a partnership to be able to be a separate entity from the partners. Open offices in new jurisdictions, all those things just became a lot easier because of the removal of joint and several liability. So just about anything that any strategic decision that a firm makes today would probably have been made differently before the advent of LLPs.
Thank you.
I think that's a really useful example about sort of how things have evolved in different jurisdictions as you go, because now we have so many jurisdictions that are able to offer that limited liability protection. For example, like the UK LLP, you find only really tiny pockets where there is unlimited liability for the people who are participating, but firms have sort of developed this global ethos where they say, well, actually, we should all be in it together. So a UK partner shouldn't be more exposed than, say, well, Hong Kong used to be the key example, but obviously they've moved on. And so there was a huge sort of wave between, I don't know, 2005 and 2018, where all of those firms said, well, actually, we, the partners of the LLP, will provide a sort of a lifeboat to these people who are still experiencing joint and several liability, who are still exposed. And because that became, it was quite a complicated little structure, but it became commonplace. And then the insurers came in and said, actually, this is quantifiable. We know how much it will cost to make good these people who are bankrupted in these specific locations. So that's an insurable sum. And the insurance industry then developed, I think Marshall had it at the time, developed these products, these lifeboat covenant insurance products. So then it was insurable. And then it was just a business cost. So it was really interesting to see how that LLP framework went from everybody's exposed, nothing we can do, to some people are exposed, there's something we can do, to this is actually just boring, it's now just a business cost. And then we've managed to get everybody into the umbrella of protection.
Nothing about what you just said is boring, Corinne, at least not for me. So But it neatly moves on to my next question, which is around, well, not everyone now has stuck with the LLP. So we've seen firms, particularly in professional services, grow, and get to a particular, often size, but not necessarily size, and that's not the prerequisite, and then decide to, for example, list. I mean, that's the big ones. But you've also got kind of at the other end of the spectrum, very small who haven't even gone for an LLP structure in the first place. They've gone straight in as a corporate structure. And so I just want to briefly just talk about that, because it's obviously been a feature of the LLP and its progression. And I suppose, Corinne, to kick off or to come back to you, what sort of impact does that have, that sort of capital event have on the business and on the partners and on the staff as well?
It's a great question, Sarah, and I think probably the answer is it's not for this discussion, because it's not actually about the LLP, is it? In the sense that this is a strategic decision. Why are you listing or accepting fee investments or doing what you're doing? You're thinking, well, what do we need the extra funding for? And I mean, I absolutely agree with the point made earlier that the LLP model has made those sorts of decisions easier. But equally, one could say, well, actually, you could go to the bank, or you could ask the partners for more funding if you had a specific capital need or a specific investment requirement. So I think we quite often look over that aspect there. And I just wonder, therefore, if there's something in the structure, in the way that firms are governed, that have made them more ambitious, sort of striving for a different type of growth, which is what's driving these questions about capital events. Because you're absolutely right. We have seen firms move, even in the 25 years that we've had LLPs, from the very traditional partnership model as it was, as in sort of, I hate this phrase, but everybody recognizes it, the naked in, naked out. You put your capital in, you get it when you get back to this state we're in now, where people are thinking, actually, is there an opportunity to sort of capitalize on my interest in this professional service firm or this financial services business? Some people would regard that as those individuals sort of selling the family silver. You've only got one chance to do that. Others would say, actually, no, this is a modern business. If you are looking for the growth year on year that stakeholders are acquiring, then you need to be ambitious, and that's just the next logical step in the evolution.
But I suppose then, turning to you, Rob, it's not just about that, because I mean, we love an LLP here at St. Murray, obviously, and I think Jeremy and Rob would agree with that. But there are things that, not that you can't do with an LLP, but that naturally, I think, when you try and look at downward incentivization in terms of looking below where the partner level and try and incentivize and pull up the other people that are vital to your business, there is a difference, I think, in what you can offer as a corporate, or at least easily offer as a corporate versus an LLP, isn't there?
Yeah, well, yes. I think that one can offer very similar things with an LLP to what one can with a corporate in terms of employee share ownership interests, even if it's a sort of a proxy interest. And so it's very interesting to see what some firms are doing very much at the fringe, and wonder whether those fringe activities are going to become more mainstream. For instance, there is one firm that I can think of that has got something that looks very much like an employee share ownership scheme, and in the form of a trust, which is one of the members of the LLP, a corporate member, if you like, and a certain amount of the profit goes into that and then is distributed down to non-partner employees, very much in the way that an employee share ownership scheme would operate in a corporate. So as things change in law firms and other kinds of professional firms too, in terms of where the value is coming from, is it coming out of the brain of a senior person in the firm, or is it coming out of the juniors and more technology? I think we're going to see more and more of that. And by that I mean, I think we're going to see partnerships, LLPs, looking at corporates and saying, how do we emulate the kind of things that you are doing to keep your staff engaged, to keep your staff loyal, to stop them from joining other firms, and how can we translate that into our firms? And I think there are ways to do that. It's not that LLPs are precluded and corporates can do things that we can't.
Yeah. It's interesting that we'll talk about remuneration, but more sort of partner remuneration in a little bit. But it's interesting because I think it is a challenge for all businesses to try and ensure that they are incentivizing in that appropriate way all the staff, because we have seen generally across the board, and Jeremy, you touched on it right at the beginning about mobility of partners, but we see mobility of everyone increasing. Year on year, people move more, people are more willing to move and more willing to kind of move for what they consider important. And that varies hugely also across, demographics and sectors, etc. So I suppose we as LLPs, advisors to LLPs, we have to become creative as to how we can offer ideas and innovation in that remuneration space, not just about partner remuneration. So I think there's quite a lot of exciting stuff ahead, actually. Jeremy, did you want to come in on that? You came off.
I mean, just a couple of thoughts. I mean, first of all, just picking up on what you just said, I think certainly anecdotally, I think the accountancy industry, which is often a little bit, dare I say it's ahead of even the lawyers, and which makes them about 400 years ahead of barristers, ahead of a solicitor's world, and therefore 400 years ahead of barristers. I think they're finding a lot of people are moving between firms because at the end of the day, there seems to be a little less loyalty within particularly the sort of junior group within many accountancy firms. I'm sure that's not the experience of every accountancy firm, but certainly people I've spoken with have commented on how much competition there is for the junior people, and often obviously the big firms are sucking them into there. So there's a less loyalty and more mobility. The other thing, just to pick up on when we're talking about sort of structures, I think with an LLP as compared to a corporate, there is a challenge, although as Rob indicated, there are models that work around these things. There is a bit of a challenge in making sure that you can sort of get value out when you leave, indeed, if that's what you want. And there is that sort of tension between, should you just say, actually, what I get is what I take out of the pot while I'm working here, versus the people who say, well, actually, no, I've helped build this business up, and I should get some money out when I go because I'm leaving something of much greater value than when I came in. So I think that's an interesting issue and a tension perhaps running through LLPs.
And Rob, very briefly, but what would, if you're a founder of an LLP, what are the sort of things you're thinking about in terms of generating that value if you want an exit?
Well, technology immediately springs to mind because what that is doing is it's creating value within firms that is fungible. It's not dependent on specific individuals. And I think the reason why one is seeing more innovative funding mechanisms and more innovative business models in the more commoditized areas of law, one thinks of conveyancing as an extreme example, is simply because that those areas of law and those areas, and the same applies to other kinds of professions, and absolutely are more fungible. They're not dependent on specific individuals, so that value can be transferred, and it's easier to sell. Well, it's very easy to sell, in fact. The Artificial Lawyer had an article a day or two ago where they said 1 in 5, I think that was right, I might have got that proportion wrong, of lawyers would move law firms if they felt that the firm was not approaching technology in the right way. That's really interesting, because that's also just indicating a differing view on value, on the value that these tools are adding to firms.
Yeah.
I was just thinking 5 people don't understand how important technology is. So, which is, but there we are, which I think resonates with some of the professional services firms partners.
I was going to pivot completely. I mean, I'd like to come back to technology in a little bit, but this is unrelated. But we cannot do a session on this without at least touching on tax. And obviously, we had to work out who we were going to strong arm to talk about that off the panel, because I have to say, as the caveat, none of us are tax lawyers or advisors. But Corinne is our sort of in-house, can I call you our in-house tax geek? Because you do love a bit of looking at the impact on members and kind of how that translates through to the impact on LLPs, etc., of tax rules that change and come out. And you've been keeping me up to date on Blue Crest, although I still don't profess to understand it all in detail. Do you want to just say a few words about how you've seen the tax position in LLPs change over the years and what the most recent changes have come out and said?
Yeah, absolutely. And as you say, I don't pretend to be a tax advisor, and I'm slightly terrified even beginning to speak, looking at some of the names of really excellent tax advisors who are listening in. And I think couple of names from the revenue too, so here goes. No, I mean, I will keep it really high level because it's a really complex topic, but I think tax has how LLPs have been used. I mean, at the very heart of it, LLPs are interesting and often used because they are tax transparent in the sense that the profits are taxed in the hands of the members rather than the entity being taxed in its own right. And that was, well, first of all, a very easy way for a partnership to shift to a corporate model, because that's replicated what partnerships were. And obviously there's a lot of technical detail in the legislation on that. But that also suited what the businesses want, what the owners wanted in terms of that income coming out. So you can sort of see why that tax transparency was a really key part of operating through an LLP. Obviously, the tax environment has evolved, and probably one of the key things for UK LLPs in terms of changes was around the salaried members rules in 2014, which again, I'm not qualified to talk about in detail, but those were the ones you'll recall where you had to have either a variable profit share or influence in the business or significant capital in the business in order to be considered and therefore taxed as a self-employed partner rather than deemed to be a sort of a disguised employee and taxed as such. And they really shifted the way that firms operated, because there were very few firms that were small enough really to qualify safely within the influence test. And therefore people had to have variable remuneration or capital in the business. And again, in lots of businesses, there was a cohort of fixed share partners, of more junior partners that sort of had that fixed share status. And again, they didn't really have variable profit share. So we saw a lot of businesses focused on that capital contribution. As a result of these tax rules, lots of people introduced capital into the LLPs when there wasn't actually in the first place necessarily a burning working capital need. I think, and I know there's tax implications in saying this in terms of what was driving those decision makings around avoidance and so on, but I think the honest reality is that a lot of firms thought more about the working capital needs and the capital coming from partners as a result of those. And so we saw firms having a great deal more capital, and that position has continued. And I think COVID, if we're thinking about society, everybody sat up and went, oh crikey, how much cash have we got in the bank? Because everybody thought business was going to drop off a cliff. As it happened, the COVID years were generally pretty strong for professional services, but there was a point in that first month where everybody looked at their bank balance and thought, how long can we survive with no income? And for some firms that was a squeaky moment at that state. And so we saw firms sort of building up working capital and sort of trying to preserve those, and perhaps not having good discipline around lockup and debts and those sorts of things in terms of generating that operational working capital. But now we've gone into this period post basis period reform, and again, you'll be delighted to hear I'm not going to try to explain that. But the punchline of basis period reform is that you won't have that tax money as a source of working capital during your business. So now we're going to see the working capital needs change again. And these sound like tax points, and they are being driven by tax changes, but actually they're about how you run the business. They're about how you interact with your clients. They're about how much money the partners need to have in the business. So I think that for me, those sort of tax points, to me, the most interesting side as a non-tax advisor is how it's changing behaviors, how it's changing the way the business needs to be operated, how it's affecting the relationships between the partners. And I mean, in some businesses, obviously it changed the way that people made decisions, or the way that people remunerated partners as well. So, and one could argue in some businesses it might have distorted it, who knows. And I think, again, getting the crystal ball out and assuming my cryptic cos persona, I think we're going to continue to see those tax factors influencing behaviours within LLPs, because it's a huge part of doing business. So when we see where things settle with Bluecrest, and obviously it continues to work its way through, will there be things coming out of that case that change the way in which firms have to operate? Or alternatively, will with legislation change? People speculate, don't they, about having to fail 2 tests. So you have to have, say, influence and capital, or influence and variable remuneration. I mean, that would be a huge issue for professional services firms. Let's not beat around the bush. So it will be really interesting to see how those changes shape the way that LLPs evolve over the next 10 years.
Thanks very much. I mean, for someone who doesn't caveats that with not knowing about tax, you've done a really good job of explaining it. Sticking with the money, I said we talk about remuneration, and we will now talk about remuneration. So I think this is one of the topics, obviously close to a lot of partners' hearts for obvious reasons, but also just quite complicated, and has seen a massive change, I think, over the 25 years that we've had LLPs, as businesses have sort of taken that much more traditional way of remunerating partners in an 1890 partnership and kind of then tried, as we've touched on briefly, to sort of be more imaginative and change the way that they remunerate partners, incentivize partners, and, as we touched on, staff. I'm going to come to you, Rob, to give us a sort of general overview of the kind of key trends that you've seen in LLP partner remuneration, and where we started, where we've got to, and where we might be going to.
So that's an excellent question, and the answer lies really, partly at least, in a point that Corinne made earlier, that it's not to do with LLP so much as it is to do with strategy, and it is to do with the evolving practice of law, and then things that firms are able to do within the LLP context that they weren't able to do before, or not as easily perhaps, because let's not forget, I mean, Slaughter and May isn't an LLP. There are a couple of really powerful firms out there that have chosen not to, and I suspect that's largely because then they don't have to report figures to Companies House. So it's a transparency thing. But if we take that aside, what can one do? Well, if you go back to the pre-LLP era, when there was joint and several liability, partners would have had a very strong argument that, well, then we all need to be compensated the same way. And that then there was an argument about, well, some people are more senior than others, and that in turn led to the lockstep. And one could very convincingly argue that the lockstep is a legacy of the pre-LLP days. Because what's happened since then is that a variability has evolved across practices according to what clients are prepared to pay for certain practices. I mean, if we take it down to a billable hour, bluntly, they're prepared to pay more per hour for some practices than others, which means that if we leave leverage out of it and we just look at it superficially, that means that some practices generate more value for the firm than others, and those partners have then said, well, we want to be compensated more, which in terms has led to modified lockstep, and in some cases more extreme performance-based systems. And I think a colleague of mine years ago once said that there are as many compensation systems in the world as there are law firms. Each law firm has got their own, but one's beginning to see more and more commonality and more common themes. And this recognition of different values is one of them. But again, technology is a great leveler, and I don't want to make this conversation all about technology, but it is beginning to change the formula, because we're beginning to see value being produced that is maybe being managed by particular partners, but it's not coming directly out. The value to the client is not directly out of their brains any longer to the same extent as it was. And if we look to the future, we can see that trend perhaps continuing. So I think that's the most important point to be made about compensation, partner compensation in the context of LLPs. It's simply, again, that the LLP is able to do more, be more flexible than ordinary partnerships.
Thank you. And then, Jeremy, what's your experience in terms of, I suppose, two things? One, have you seen particular trends or things that we as LLPs have imported from, the more traditional sort of banking sectors, etc.? And also, do you think that has led to more disputes around partner remuneration?
So on the first question, I mean, I think Rob's obviously the expert on all this, but you do see quite imaginative remuneration structures being built into LLPs, and that is very often drawing on sort of banking world and the even more corporate world. So yeah, there's a lot of flow through. But in terms of disputes, and I suppose a lot of agreements will have an appeals process built in, which you do see being used quite vigorously by discontented partners, and given the complexity really of working, I mean, it is a difficult subject to work out whose contribution is worth what, if I can put it like that, because there are so many different elements, as everybody knows. It's the sourcing of the work, it's the doing of the work, it's the more soft skills, managing people, helping other people grow their career, and then all the stuff around managing and governing businesses. So how do you weigh up the relative value of all those components? So it isn't straightforward, as we all know. And I suppose what I do see is a trend towards more and more sort of criteria built into agreements, so that there's greater transparency about what the mechanisms and matrices are that are being used in order to come to a conclusion. So I think that's one trend. The other thing as well is, and this is getting legal, here we go, warning, that obviously we've got the fact that these are generally discretionary decisions. So we have seen the rise and rise of Braganza, which in old money is Wednesbury unreasonableness, being used in ever more contexts. And certainly we've got the example or the case of Tribe and Elborn Mitchell in the LLP context, where unsurprisingly, when one thinks about it, that decision of profit sharing was said by the judge to be an evaluative assessment type decision, which was susceptible to Braganza duties, and therefore relevant factors had to be taken into account and no irrelevant factors. That's the process limb, and it couldn't be a decision that was so unreasonable that no reasonable group of decision makers could have come to it. That's the outcome limb. So Braganza was applied to a remuneration decision. But so the flip side of that coin was that the judge went on to say that whilst it did apply, the hurdle was a high one, and actually it wasn't, the decision that was made wasn't outside the ambit of reasonable decisions in the first place. So yes, I think we're going to see more and more sort of challenges being brought against a remuneration process using both the internal appeals process built into the agreement and potentially sort of Braganza type duties.
Yeah, it's interesting to kind of pick up on those 2 points between Rob and Jeremy, because actually one of the things that may cause more challenges and more litigation in this is the technology, and then how do you reward the adoption and the growth and the invention of technology versus how do you reward what we're all much more used to seeing is like people's time and the kind of amount of work they put in. I think that will obviously cause potential disputes, because you can see very easily that as between even specialties within, say, let's take a law firm or an accountancy firm, different specialties will, have an easier road into technology than others, and then that might create further disputes. So it would be really interesting to see how that develops. You apologise for getting legal, but I'm going to keep you there, Jeremy, and move on to the kind of big legal topic. So the duty of good faith. So obviously, we are all probably quite familiar with the kind of 1890 partnership, duty of good faith, and how that's developed in LLPs. I'd like to just explore that a little bit in terms of, I guess, where did we start with the duty of good faith? What were people like Corinne, who draft agreements, putting in at the beginning? And what trends you have seen develop in terms of what people are now putting in, or specifically not putting in terms of the duty of good faith in LLP agreements.
Right, here we go. 5-minute summary. I'll try my best. Okay, I mean, I think the first thing to have in mind is that we need to distinguish between, and this is often something that gets confusing, we need to distinguish between a contractual duty of good faith and a fiduciary duty of good faith. They are different creatures. So in your agreements, which is what you just mentioned, you will often see, and I'll come back to the sorts of clauses you see, a contractual duty that you will show the utmost good faith to, and I'll come back to the to bit in a moment. That is a contractual duty of good faith. By contrast, for example, an agent owes his or her principal a fiduciary duty of good faith. And in the LLP context, members are fiduciaries of the LLP. And what's the difference between a contractual duty of good faith and a fiduciary duty of good faith? Again, could talk for happy hours on the answer to that question. But in summary, if you owe a fiduciary duty of good faith, you are obliged to subordinate your own personal interest to those of your fiduciary. Whereas if you owe a contractual duty of good faith, you are obliged to take into account the duties of your fiduciary, but not to subordinate, the interests of your fiduciary, but not to subordinate your interest to those of your fiduciary. So that makes quite a big difference legally to the nature of duty. So in simplistic terms, a fiduciary duty of good faith is a stronger, more far-reaching duty of good faith. So that distinction is important. So very brief overview. If we start with the fiduciary duties of good faith, obviously in a traditional partnership context, every partner is the agent of every other partner. There is no separate legal entity because the partnership is not a separate legal entity. It's just a collection of individuals carrying on a business in common with a view to profit. So everybody's each other's agent, and therefore everybody owes each other a fiduciary duty of good faith, because going back to what Rob was saying, each can fix the other with liability by their actions. So by contrast, in an LLP, we have a corporate entity, the LLP. So that raised the very interesting question of how fiduciary duties work in an LLP. We have a very, very long decision, F&C Alternative Investments and Bartholomew. If you aren't sleeping well, have a read. But the guts of that was to say no to the idea that the mere fact that you are members together in an LLP means that each member owes every other member a fiduciary duty. So no fiduciary duty arises merely from you being a member, because, as I said a moment ago, members are the agents of the LLP. So the member, if acting as agent, will owe a fiduciary duty of good faith to the LLP, but not to every other member. So the case explains that members may owe fiduciary duties to each other, but only where they've assumed responsibility for another's property or affairs. So a slightly narrower, or very much narrower, category of fiduciary duty owed member to member. So let's come back to the contract. What do you see more and more in contract? So when LLPs came into existence, one of the important philosophical questions was what you should put into your contract in terms of duty of good faith. Who should you say members owe duties of good faith to? There is a division in drafting, which Corinne will be very familiar with, between those where they have said all the duties of good faith are owed only to the LLP. So that kind of synchronizes with the fiduciary duty. So the much more prevalent type of clause will say that members owe duties of good faith to the entity, to the LLP, not to each other. Sometimes you see in LLPs express contractual clauses of duties of good faith being owed member to member. That is very much almost a philosophical debate. I mean, I remember shortly after LLPs came in, I was called in to assist with a merger of two law firms. And I remember sitting around a large table with sort of 4 representatives of each firm, and they were going to form an LLP. And then we got to this question about duties of good faith. And one side of the table said, well, yes, we should be, we're all partners. We've all owed these duties of good faith to each other in the past. We want to run a sort of collegiate firm in the future. We should all say expressly that we owe each other duties of good faith. The other side of the table, the other firm said, no. The whole reason that we're becoming an LLP is because we want to have a situation where we're more corporate, where we actually work in an environment where we owe our duties to the entity and we do the right thing for the entity. And there was a very stark philosophical divide between the attitudes. So I think that's a long answer to your question. I think in terms of what you see in clauses, you start to see more and more. My experience, and I'm interested on Corinne's, is that it's becoming ever rarer, I think, to see a clause that says a duty of good faith is owed member to member. I think the significant majority of LLP agreements will say, no, we're now in a corporate structure, duties are owed to the LLP. A throwaway bonus ball, I'm interested to see what you don't see very often is many duties being owed by the LLP to its members. And that's an interesting one. And I think you could see it as part and parcel, perhaps, of a sort of more caring corporate environment, perhaps seeing a greater amount of the LLP being said to owe duties to its members. I doubt that would be a blanket duty of good faith, but you might see more specific duties coming in.
Corinne, you want to come in on that?
Well, yeah, I was going to agree wholeheartedly with all that complicated legal analysis, maybe so I don't have to actually go through it myself. But I think in practice, and that's absolutely right, we have seen that evolution, and it is very rare to see those duties of good faith kind of owed contractually between members compared to, say, 2005. But where we do see it play out is that it kind of creates weapons in the hands of disgruntled partners, just thinking about it from the firm's perspective, because if a disgruntled partner's got an axe to grind of any sort, they'll seize on that duty of good faith and say, oh, this is it, you know. And so you see these it very rarely comes down to that philosophical question of how should we be behaving. It then turns into how can this be weaponized by either the firm if they're trying to penalize, for want of a better word, an individual partner, or vice versa if the partner is looking for chinks in the firm's armor. And I think that's where we actually see it play out, not in the actual influencing of overall behaviors. And I think that sort of bonus ball question about where this is going in the future and whether LLPs will owe duties, I'd be really interested to see that too, Jeremy, because we're seeing outside influences influencing that question, aren't we? For example, the SRA as the legal services regulator imposing very high standards of kind of workplace culture and conduct on the individuals within it, the managers of those firms and the firms themselves. And we're seeing obviously the ICAEW and the FCA increasing that focus on non-financial misconduct. So we're already seeing, and then there are laws like the duty to prevent sexual harassment and those sorts of things that were already there, and health and safety protections. So you do sort of think, well, hang on a minute, why isn't this codified in the LLP agreement? So maybe that's what we'll spend the next 10 years doing, sort of putting those aspects in to bolster those duties owed by the LLP to its members.
Yeah, that's I think that's very interesting observations. I mean, I think just picking up on one thing you just said, Corinne, if I may, this point about weaponizing is a very good one. I mean, in practical terms, that if you choose to put in a contractual duty of good faith owed member to member, you do run the risk that a disgruntled member will say, well, I'm now going to sue that managing partner personally because he or she owes me a duty of good faith, and therefore I say they're in breach of that duty of good faith, so I'm going to bring a personal claim against them for breaching their contractual duty to me. So again, that starts to run a bit of a coach and horses through separate corporate entity and corporate liability being limited. So there's that risk in building personal liability member to member through that sort of contractual nexus of a duty of good faith, if you choose to put that in.
Yeah, and actually we see in some agreements, and again, I think this is a relatively modern trend, where there's a specific provision that says that management team members don't owe duties in the exercise of their management functions. And on the one hand, that protects against the risk that you rightly point out in that weaponization space. But equally, it doesn't really look good on paper, does it? As management can do what they want and there's no comeback. That is not a good sell to, say, incoming members, or just talking about sort of workplace culture and culture generally.
And that's, I think, one of the key points is partly around the messaging that you're sending about the type of kind of business you want to be. So there's often good legal reasons as to why you might exclude or not include certain things, but actually there's a bigger question. Let's come back to your point, Jeremy. A lot of it is philosophical when we're talking about these things. But that leads me on to a very quick summary that we just want to quickly touch on: litigation trends. So obviously a subject close to my heart. Because am I one of those people like weaponizing? I don't know. I hope that's not what it's seen as. But enforcing the rights of firms as against members who've done bad things, and enforcing the rights of members as against firms who've done bad things. So we've seen a lot of litigation. As in, if you're in practice in litigation, you see a lot of litigation. But Jeremy, I suppose the obvious point is we don't see a lot of case law because almost all of this is done in secret, right? And do you think, the big question is, do you think we'll get a body of case law for LLPs in another 25 years? Or do you think we'll have another 25 years where basically we will end up with a few key decisions on which we're all trying to base our advice, some of which are very historic? What's your view?
That's a great question. I can't think of my equivalent to cryptic cos, but there we go. Yes, I mean, look, it is interesting in the legal nargy way how little case law there is, but there is a good reason if one unpacks it really. First of all, most LLP agreements, particularly in the professional services space, will build an arbitration clause into their agreement. So if there is any sort of litigation at all that goes the distance, it's probably going to be in an arbitration, which, as everybody knows, is confidential. But the reality is the vast majority of cases settle. I don't know exactly what the statistics are, but I would probably say my experience, perhaps 95%, of them settle for very good reasons. We're all litigators. We live, well, but many of us are litigators. But the reality is, would we want to be litigating our own disputes through a court hearing all the way to the end? It would probably be a last resort and not a first resort. So litigation is used as a means to achieve a result, which means many disputes settle. So I think that's driver one. I mean, if one just takes a step back, the fact that in the LLP space, we really don't even have a decision around restrictive covenants, one would have thought if anything was going to fight the distance, it would be a restrictive covenants issue, because that's in pretty well every LLP agreement, and everybody, well, not everybody, but many people will test the boundaries of those, and you'd expect that would be where there'd be some litigation. All we've got is still Bridge and Deacons from the 1980s in the traditional partnership space, and a decision of PwC and Carmichael looking at it at a interim injunction, sort of good arguable case type level, but not a full analysis, and a bit in Australia. So that would suggest it's that decision making full Monty in front of the courts hasn't flooded in over 25 years. There's no obvious reason why it would. I think the areas where one is likely to see decisions in the LLP space are in tax-related litigation. Bluecrest's an example, obviously, but there are lots of other interesting tax points that may end up being litigated. Also, in the employment tribunal, discrimination-related whistleblowing type claims is another sort of fertile or more fertile route. Again, obviously, that isn't susceptible to being caught by an arbitration clause, and it is public. So, that's another space. And I think another possibility, maybe given the amounts of money involved in the financial services sector, one might see some of those fighting longer distances. But I wouldn't count on a massive body of case law, which makes it all fascinating, because we have to work out what the answer ought to be, rather than having judges telling us what they think the answer is. So that makes it even more interesting.
It does make it more interesting, although sometimes you do the inability to give any kind of certainty on some questions can be challenging. And it's interesting you say about the employment tribunal, obviously is public because it's not subject to arbitration, but I think that's one of the very factors that often causes those cases to settle at an earlier stage, whereas in arbitration there's less of that aspect of it is less of a consideration for the parties. Obviously there's the costs and the general lack of attractiveness. We've got a few minutes left, so I want to just come back to Rob to just talk about sort of overall trends that you would pick up on in terms of, and you've touched on this already, and you've mentioned technology, but any other sort of trends? And I suppose my big question is, will there be LLPs in the future? Will they drop away completely? I really hope not. But what kind of trends and things that would you say we've got to look out for?
I'll answer that in a second, but with your permission, I see there's a question here from Jason Big. May I address that first?
Of course, yeah.
He asked, remuneration on the lockstep seems fair when contribution might not be just be fees raised, but actually running a business. I think the answer to that really goes back to what I said about the number of compensation systems being equal to the number of firms in the world. The most important thing is that partners need to perceive the compensation system to be fair and the process by which it's administered to be fair. And if they perceive it to be fair, then you can run a lockstep, you can run whatever system you like. And I think that applies here. So if you wish to measure other things and then translate like contribution of technology and then translate that into a lockstep, then and the partners think that's fair, then it works. If they think it's not fair, then it won't work. And I think that in a way talks to where LLPs are going to, because things are becoming far more complex. Business is becoming far more complex, so a lot more matters to include in strategy and the way that business models are constructed. And personally, I don't think that we are going to get away from LLPs, because it's the most sensible way of running a partnership today in the kind of environment that we have, and that's going to persist. And how else do you have a business of really bright people advising, pooling their efforts to advise clients together? It doesn't really fit. That kind of thing doesn't really fit into a corporate model purely. And I think if it did, it would have collapsed by now. We wouldn't be seeing partnerships anymore. But the very fact that we do see partnerships and they are thriving suggests that there's a very robust future for LLP.
That's positive. I like that. So in 30 seconds each, Jeremy and Corinne, your favourite thing about the LLP?
Corinne, do you want to go first?
You can't pick your favorite child. I can't pick my favorite thing about an LLP. You said 30 seconds. No, I think flexibility. That flexibility, that opportunity, the kind of the shell that enables participants who are owners, managers, and workers to sort of drive their own future. I think that to me is probably lots of things in one, if I can pick one thing.
Jeremy?
My favourite thing, from a Nagy lawyer perspective, how fascinating the legal issues are. From a real world perspective, the fact that you're dealing with people's lives, fascinating issues that evolve every day in terms of management, and an awful lot of very impressive individuals trying to do their best and using a structure for positive purposes. So I'm glad to hear Rob thinks there's a future for LLPs, because 25 years is just a drop in the ocean, and long may they continue.
Thanks very much. Yeah, no, I totally agree. I'm relieved to hear that is Rob's prediction. Cosmic, I can't even remember what your name is now, Corinne. But, a lot of feature looking on this session. And that brings us to 10 o'clock and to a close. So thank you so much for the panel, for your contributions. I hope that the session has been enjoyable and informative. That was the purpose, to not just kind of give you some information about the law or LLPs, but to also just take a nice reflective look back through the last 25 years about what we like about them, what we've seen change, and what we think the future might hold. And so hopefully you've got something from some of those aspects of our session today. So thank you all for listening in. Thank you to Rob, to Jeremy, and to Corinne for your contributions and your experience, and for sharing all that with us. Rob, I hope you make the rest of your journey safely. And I hope everyone else has a really good Friday and weekend. And obviously, as I say, this was recorded, so if you want to listen back or share it with colleagues and friends, then obviously you'll get the opportunity to do that. So thanks, everyone.